Hi, I'm Kelly Brotherhood. I am here today to speak to you about the end of the beginning of Scottish QOCS. This is my second vlog on qualified one-way cost shifting, QOCS coming to Scotland. It should be considered with my previous vlog and blogs, all of which are available on the BLM policy blog. We are calling today's vlog the end of the beginning for Scottish QOCS. This will happen on 30th June 2021. QOCS in Scotland has had a very long beginning. As we approach the end of the beginning, it cannot be emphasised enough that what comes after 30th June 2021 will be at least as important as, and arguably more important than, what has happened before then. Today's vlog will try to explain why. Let us look at the important background context. September 2013 saw the publication of a report by the late Sheriff Principal James A. Taylor following a review of expenses and funding of civil litigation in Scotland. Nearly 5 years later, on 5th June 2018, the Civil Litigation, Expenses and Group Proceedings Scotland Act 2018 received royal assent. Simply put, the court must not make an award of expenses against the pursuer in a litigated personal injury claim or any appeal in the claim unless the pursuer's conduct or behaviour is inappropriate as defined in the Act and in court rules made under the Act. A further 3 years later, on 30th June 2021, the Civil Litigation, Expenses and Group Proceedings Scotland Act 2018, Commencement No. 4 and Transitional Provision, Regulations 2021, come into force. These regulations bring Section 8 of the 2018 Act into force, but on a non-retrospective basis. So QOCS only applies to claims made on or after 30th June 2021 and any litigation arising from those claims, and claims made before 30th June 2021, but only where any litigation arising from those claims is commenced on or after 30th June 2021, and with any behaviour or conduct in connection with the claim before then being excluded. Also on 30th June 2021, rules of court will come into force providing further qualifications on what counts as inappropriate conduct or behaviour under the 2018 Act. These rules also deal with the practicalities of how applications are to be made to establish a qualification and how the court should approach such applications. Let's look at all of the qualifications. These are where the pursuer or their legal representative makes a fraudulent representation, which is to be proven on the balance of probabilities, or otherwise acts fraudulently in connection with the claim or the proceedings, behaves in a manner which is manifestly unreasonable in connection with the claim or the proceedings, or otherwise conducts the proceedings in a manner that the court considers amounts to an abuse of process. Or where one of these things happen: failure by the pursuer to obtain an award of damages greater than the sum offered by way of a tender, unreasonable delay on the part of the pursuer in accepting a sum offered by way of tender, abandonment of the action or the appeal by the pursuer, whether under court rules or at common law, where, in the limited circumstances that apply, the pursuer's case is summarily dismissed by the court because it has no real prospect of success and there exists no other compelling reason not to grant summary dismissal. Where the court makes an award of expenses against the pursuer on the basis of one of the tender-related qualifications, the pursuer's liability is not to exceed the amount of expenses the applicant, usually the defender, has incurred after the date of tender. The liability of the pursuer to the applicant or applicants who lodged the tender is limited to 75% of the amount of damages awarded to the pursuer. Where the award of expenses is in favour of more than one applicant, the court, failing agreement between the applicants, is to apportion the award of expenses recoverable between them. None of the other qualifications to the cost shift are restricted in these ways, which means that where any of the other qualifications are established, the court may award to a defender their full judicial expenses against the pursuer. Nothing is said in the rules on what amounts to unreasonable delay for acceptance of a tender. That will be for the courts to determine. In my pre-QOCS experience, 7 to 21 days has often been considered an appropriate period, with relevant factors including the complexity of the case and the stage the proceedings are at when the tender is made. One question worth thinking about is what if the delay in accepting a tender is manifestly unreasonable? Judicial discretion will continue under QOCS. Pre-QOCS, judicial discretion was the cornerstone of Scots law on expenses or costs in civil litigation. In Howard v Alexander and Sons, Lord President Cooper observed that an award of expenses, according to our law, is a matter for the exercise in each case of judicial discretion, designed to achieve substantial justice and very rarely disturbed on appeal. I gravely doubt whether all the conditions upon which that discretion should be exercised have ever been, or ever will be, successfully imprisoned within the framework of rigid and unalterable rules, and I do not think that it would be desirable that they should be. Clearly, QOCS interferes with judicial discretion. However, the court rules on QOCS themselves stipulate that the determination of an application is at the discretion of the court sheriff. So on each occasion that a defender seeks to establish a qualification, there will be an exercise of judicial discretion, presumably and continuing Lord President Cooper's legacy, designed to achieve substantial justice on whether an award of costs is made. A further example of continuing judicial discretion under QOCS is that where the court makes an award of costs against a pursuer because of abandonment by the pursuer under rules of court or at common law, the court may make such orders in respect of expenses as it considers appropriate, including making an award of decree of dismissal dependent on payment of expenses by the pursuer within a specified period of time, and provisions for the consequences of failure to comply with any conditions applied by the court. Why is judicial discretion continuing under QOCS significant? The continuing role to be played by judicial discretion under QOCS is significant in several ways, including different judges and sheriffs may take different views on what counts to establish, for example, a fraudulent representation or manifestly unreasonable behaviour. Different judges and sheriffs may take different views on what counts as unreasonable delay for the acceptance of a tender, and on whether any such delay amounts to manifestly unreasonable behaviour. Different judges and sheriffs may take different views on whether to make an award of expenses against the pursuer with reference to the same qualifications. To an extent, judges and sheriffs will be able to continue to seek to achieve, via judicial discretion, substantial justice in issues of expenses in personal injury cases. An appellate court is only likely to interfere with a discretionary decision on expenses if there has been an obvious miscarriage of justice or a question of principle is concerned. It will take some considerable time before there is a settled consensus on what counts as, for example, a fraudulent representation or manifestly unreasonable behaviour, due to different outcomes before different judges, appeals against discretionary decisions on expenses being generally discouraged, and the very high bar for a successful appeal. So how are applications for an award of costs against a pursuer in a personal injury action to be made? They must be in writing. They may be made at any stage in a case prior to the court's disposal of expenses. They may be based on one or more of the qualifications to the cost shift. There is nothing in the court rules to prevent multiple applications for an award of costs against a pursuer. Where an application is made, the court may make such orders as it thinks fit for dealing with the application, including an order requiring the applicant to intimate the application to any other person, requiring any party to lodge a written response, requiring the lodging of any document, or fixing a hearing. What is likely to happen after the end of the beginning on 30th June 2021? There may be a surge in personal injury litigation, including claims held back from litigation pending the implementation of QOCS. There are likely to be cases in which defenders will make applications to seek an award of expenses against a pursuer on the strength of one or more of the qualifications. There are also likely to be cases where property damage losses and/or credit hire costs are sought in addition to personal injury heads of claim, where defenders may seek expenses for the non-personal injury aspects. I would suggest that defender insurers and their solicitors start collecting data on the operation of QOCS, and in particular look at the volume of personal injury claims and litigation, and any changes in pursuer conduct and behaviour under the QOCS regime. This data should come in useful after June 2023, since after then, Scottish ministers must lay a report before the Scottish Parliament on QOCS regarding access to justice. Thank you for listening. We've prepared a paper analysing the qualifications to the Scottish QOCS shift. Please do contact me if you would like a copy. I hope you found this useful.